Welcome to today's Davies Collison Cave Legal Update webinar. I'm Fiona Galbraith. I'm an intellectual property lawyer and managing associate, and I have the pleasure of introducing the three speakers to you today. The theme of the webinar is manufacturing and research and development, and the focus is on recent government initiatives and intellectual property protection. 2020 has brought Australia's capabilities in these areas into sharp focus. In the beginning of the year, industry and government quickly collaborated to shore up Australia's supplies of medical and protective equipment and medical devices, particularly ventilators. There was also and continues to be intense efforts in the R&D and manufacturing fields to develop an effective, large-scale vaccine for COVID-19. The importance of a strong manufacturing and R&D sector has never been clearer. Which brings me to our first speaker. Craig Finlayson is a principal lawyer and he heads up Davies Collison Cave Law's commercial and tax group. Today, he'll be talking about initiatives in the recent 2021 federal budget, which are aimed at fostering Australia's resilient and competitive manufacturing industry. Following Craig, Edith Hamilton, a senior patent counsel in DCC's engineering group, will speak about when a patent or a trade secret will work best. And I hear she will be joined by some special guests too. Following Edith, Ian Drew, a principal in DCC's trademark group, will talk about trademark issues in manufacturing and OEM, original equipment manufacturing arrangements. The session will run for about 50 minutes. Afterwards, all the presenters will be available to answer any questions you may have. Please type your questions in the Q&A box as the webinar progresses. I'll now hand you over to Craig.
Good afternoon and welcome to my presentation on tax incentives, research and development investment. This is by way of an update on the back of government announcements. So as was foreshadowed in the 2020-21 budget, the aim of the budget was to increase consumer and business confidence, to grow the economy and create jobs. As part of that package announced by the Treasurer, a boost to the R&D investment was announced, involving some material reforms to the research and development tax incentive. Just a quote there from the Treasurer, we're providing $2 billion in additional research and development incentives, removing the cap on refunds, lifting the rate and rewarding those businesses that invest the most. So what is the R&D tax incentive? The R&D tax incentive reduces company R&D costs by providing targeted tax offsets for eligible research and development expenditure. And quite simply, it's designed to boost competitiveness and improve productivity by encouraging investment in activities that would otherwise not be conducted, provide an incentive for smaller organisations and provide businesses with predictable support. The current R&D tax incentive system replaced the R&D tax concession system from 1 July 2011. So what's the current system pre the announcements in the 2020/21 budget? Essentially, entities with an aggregated turnover less than 20 million are eligible for a refundable tax offset. That's important to note. It's a refund situation. All other eligible entities are entitled to a non-refundable tax offset. The rate of the tax offset is reduced to the company tax rate for the portion of the entity's national R&D deductions in excess of 100 million in a single income year. So what were the changes that were specifically proposed to the R&D tax incentive system from 1 July 2021? The government announced a boost to this system by abandoning its controversial Tax Laws Amendment Research and Development Tax Incentive Bill 2019, and that bill sought to reduce $1.8 billion from the scheme. You will have seen or noticed over the previous year or so significant articles in the Fin Review and other outlets in respect of these proposed cuts. And there was certainly significant debate and concern about the R&D tax incentive proposed cuts. So that's gone. And then from July 1, 2021, businesses with turnover of 20 million or less per annum will receive an increased refundable tax offset from the current level of 13.5 to 18.5, and the 4 million total refund cap will no longer apply. All other businesses will benefit from a simpler two-tiered system that boosts the R&D tax offsets for a spend of more than 2% of their expenditure on R&D. So put in a table form, you'll see down the left-hand column the position up to 30 June 2021, and then the position from 1 July 2021. In the first right-hand column beyond that, turnover of less than $20 million. This is the aggregated annual turnover test. There is a refundable offset, so currently 13.5% up to 30 June 2021. From 1 July 2021, 18.5% above the prevailing tax rate, so an increase of 5%, and the removal of the $4 million total cap. For businesses with a turnover of $20 million or more, and calculated on an aggregated turnover test, which is a non-refundable offset, you will see the three different thresholds of 4.5%, 8.5% and 12.5%, which kick in depending upon the amount of the percentage of R&D to total expenditure. So 0 to 4% is 4.5%, 4.9% is 8.5%, and greater than 9% is 12.5%. That's the current system. From 1 July 2021, it's 8.5% for amounts between 0 to 2% and 16.5% above amounts which are greater than 2% of total expenditure. So as you will see, there are significant increases in the concessions that are now available for R&D, research and development expenditure. And just finally, I just wanted to make one overall observation. It's a system that's only available to companies. So this means that if you've got a company acting as a trustee of a unit trust or a partnership of trusts or some other structure that is not a straight trading company, you are not entitled to claim any of the R&D tax incentives. So it was a very short presentation. It was really more to highlight the recent budget announcements and what they mean. It's a complete U-turn from the $1.8 billion proposed cut, and it should certainly assist many businesses out there in conducting R&D expenditure and hopefully helping the economy to grow post-COVID. Just like to thank Felicity and Della Nagore and Jacqueline Simpkin for assisting me with the presentation. Thank you.
I'm Edith Hamilton. I'm a Senior Patent Counsel in the Mechanical Engineering team at DCC's Patents Group. And today I'm going to be looking at the choice between pursuing patent or trade secret protection. Now, when you're looking at patent or trade secret protection, sometimes the decision is clear. Some developments are best suited to patent protection. Patents are a registered IP right for protecting novel, inventive, and useful inventions, including products, methods, or processes. They're a clear winner when your intellectual property is going to be made publicly available by the product you're going to sell, or if your innovation is something that can be readily reverse engineered. Trade secrets perhaps can be best described as confidential information of a commercial character. These are really useful for certain types of information that aren't eligible for patent protection, such as recipes or plans. Where things get interesting is when you're dealing with the sorts of inventions that fall within the overlap of patents and trade secrets. These can be things like in-house technology, sorts of technology that really come into play in a manufacturing context. These are things like manufacturing processes or the bespoke equipment using for making certain products. This sort of information might be the sorts of things that you can keep a trade secret, but it's also equally eligible for patent protection. So the question is, how do you make a decision on which form of protection you're going to pursue? It's important to bear in mind that patents and trade secrets have slightly different purposes. Now, the purpose of patent protection is it gives you a right to exclude others from exploiting your invention. And as a registered IP right, it's got a fixed term of typically 20 years, although some pharmaceutical inventions are eligible for a longer term of up to 25 years. A trade secret, on the other hand, is really directed to providing a protection against the unauthorized use of your confidential information. And this is going to affect which option might be the best for you depending on your commercial goals. To get some perspectives on the sorts of strategic considerations you might want to consider when choosing how to protect your IP, I spoke to Jane Perrier and Karen Hallerstein, who are the managing directors of Effervescence. Effervescence is an IP consultancy joint venture between Jane, Karen, and Quantum Intellectual Property Limited. Quantum Intellectual Property Limited is also the owner of Davies Collison Cave. Jane and Karen were kind enough to share their thoughts on the sorts of things that are considered significant to potential investors and partners when you're talking about patents or trade secrets. So Jane and Karen, many thanks for agreeing to speak with me today. Now, I would love to hear your thoughts on the strategic considerations that might play out in the context of the valuations of patents and trade secrets.
Thanks so much for asking us to be part of the video, Edie. Both patents and trade secrets are potentially material business assets, and as such, they can be strategically and financially valuable to a business. Like other material assets, patents and trade secrets are both capable of being reliably and robustly valued, in that their economic worth can be assessed and measured in a similar way to, for example, land. While valuation of intangibles is sometimes considered to be a dark art, patents and trade secrets are actually valued in accordance with accounting standards and international guidance and principles. There are a number of different methodologies, and in our experience, a valuation which includes a quantitative economic analysis and a qualitative technical and legal assessment of the underlying IP, that's the most effective. A reputable valuation provides accurate and transparent financial information to assist informed decision-making by boards, investors, lenders, and others. For example, in the context of raising capital or selling a business, or trying to set a fair royalty fee for a license, or even to help facilitate in a dispute resolution. Valuations are perhaps particularly important in the context of trade secrets. Many investors and purchasers see patents as a rubber stamp of value. That is, that it automatically recognises that an invention has met the high standards required by the Patents Office, and therefore it's an inherently valuable thing. The value of a trade secret can sometimes be less obvious. So an economic valuation from a reputable provider can really help provide assurance to third parties about the economic worth of a trade secret.
Mm-hmm. So in your view, when someone is considering patenting and trade secret protection, how might they optimise the value of their IP?
Great question, Edie. So in the case of both patents and trade secrets, the valuation of the asset is going to be impacted by the scope and the strength of the IP right. In the same way that if you've got a rusty car that's missing a number of parts, it's unlikely to be valued as highly as the same model which is kept in pristine condition. In the case of patents, the key considerations to optimise value are going to include seeking protection early before public disclosure of the invention, working with a great patent attorney like Edie, so that the scope of protection is adequate, and making sure that the claims cover what your invention actually does and that it's filed in the right countries and so on.
And then you'll want to monitor the market to identify businesses that might be free riding on an invention when perhaps they should be licensing it. In the case of trade secrets, the key is really going to be around having these good frameworks to protect the confidentiality. So the value of a trade secret is going to be heavily dependent on the protocols and measures to keep it secret. So they're things like physical protection, safes and locks, cyber protection by encryption, passwords, firewalls, protocols for reducing the number, of people who have access to the information, or the people who have access to the whole store of the information. You might want to divide it up to reduce the risk of disclosure. And also the infrastructure and processes for sharing with third parties. So you'll want to make sure you have good NDAs and terms and conditions for access. So these kind of frameworks are going to help firstly safeguard the secrecy and value of your trade secret, but also provide assurance to investors, prospective purchasers and partners, showing them that you've got your IP in order and that the business is one that they are interested in being involved with. And in the case of both patents and trade secrets, an economic valuation will certainly also be enhanced by robust governance and risk frameworks aligned to your business strategy and commercial objectives.
Mm-hmm. So in your view, when someone is considering patenting and trade secret protection, is it that patents or trade secrets are perceived as stronger or better, or vice versa? Is there something that investors seem to have a preference for?
Yeah, who's the favourite child?
Exactly, who's the favourite child?
Look, in that context, it's really no one size fits all. It depends on
that's code for we love all our children. We love all our children.
No favourites in the IP family.
Look, it really depends on how important IP is to your core strategy and which elements of IP are relevant to that core strategy, how your business is intending to use or commercialise your intellectual property, how easy it might be to protect a secret, what your budget is, a whole range of factors might be considered. And I think it's also helpful to think about what commercial objective you're trying to achieve. So if you're looking to attract a partner, it might be that your partner has a preference one way or the other. For example, if you're looking to partner with a university or with a government or with a commercial enterprise, they may have a particular view on whether they prefer a patent or a trade secret. So that might sway you one way or another. Similarly, if you're looking to secure freedom to operate and you're going into a new market or you're going into a location, a new geography, then again, that might determine whether or not you think about a patent or a trade secret, or in fact both, for your innovation.
Yeah, good points, Jane. And as Jane says, investors and purchasers, and some in particular, absolutely do like to see patents. And we talked earlier about, they're seen as this sort of rubber stamp and a shorthand way to demonstrate value and commitment to IP. But a trade secret with a great confidentiality protocol and evaluation report to back up its inherent value can also be very impressive to investors. So it really is this matter of taking the time of strategically considering which is the best fit in each circumstance. And of course, a really effective way to do that is as part of an overarching IP strategy, which aligns your patents, your trade secrets, and all your other IP to your business priorities. But that's probably a topic for another day, Evie.
It's all part of working out exactly what's going to work in the context in which you're working. No,
absolutely, exactly.
Now, if Jane and Karen's comments have got you thinking about your IP governance, I'd really encourage you to check out DCC's October webinar that has some valuable insights on things that you might want to bear in mind when preparing documentation to put yourself in a really good position for protecting your IP. It also has some very valuable guidance on confidentiality agreements, which are really important, particularly in the context of trade secrets. Now, on the topic of trade secrets, one important thing to remember is that they relate to the use of your confidential information. They don't stop somebody independently developing the same invention as you that you might have kept secret. So they don't stop independent development, which raises a really interesting question. What do you do if you've got a trade secret, but then somebody goes to patent the same invention independently? Well, fortunately in Australia, we have some exemptions to infringement, in particular one for prior use. Now, this is to help people who are exploiting a product, method, or process that would infringe a patent, but were already doing that prior to the priority date of the relevant claim of that patent. Now, there's a few different parts to section 119, so I'm just going to step through them and highlight a few things for you to consider. So the first thing is that the exploitation or definite steps to exploit must have commenced before the priority date of the claimed invention. The other thing to bear in mind is that this exploitation must have taken place in the patent area, which is Australia, or the Australian continental shelf, the waters above the Australian continental shelf, or the airspace above Australia. The other thing to think about is, at the moment, based upon available case law, the exact meaning of definite steps to exploit the product, method, or process isn't entirely clear. Some of the case law to do with the previous version of section 119 gives some indications. Based upon that, it indicates that a specific plan to make a patented product is likely to constitute definite steps to exploit. On the other hand, if you're considering a number of different options, one of which might be making a patented product, that may not meet the threshold. And it's important to bear in mind that because we're dealing with patent protection that's being pursued independently, you're not going to have a good idea when this patent application might suddenly be filed. So there is a risk that you've got to think about, particularly if you're working in a technology space where you're likely to see a lot of independent innovation. Now, continuing to have a look at section 119, some other things to bear in mind is that you've got to continue with exploiting or taking the steps before the priority date. You don't want to have stopped or abandoned those steps before the priority date of the claimed invention. Once again, you've got to bear in mind, you're not going to know exactly when that patent application is going to be filed. The other thing is that you don't get this exemption if your knowledge of the invention has come from the patentee, unless, of course, the relevant information was made public by the patentee or their predecessor in title. And finally, an important thing to bear in mind is if you are eligible for this exemption as a prior user, it is possible to transfer your entitlement to another party, which can be important when you're thinking about how you might be dealing with your business and any future plans. But it's also important to bear in mind that that entitlement has to be disposed of in its entirety. You're not allowed to divide up the entitlement and share it up. One hit. Now, if you're looking at all of this and thinking, I'm still not sure what I would like to choose, that isn't necessarily a problem. There is a good period of time in which you can consider both patent protection or trade secret protection. On this, it's important to bear in mind that a whole load of inventions start their lives as trade secrets. That initial development stage, before you've filed your first patent application, you're keeping that information a trade secret, you're not disclosing it. So you can see early in the patent life cycle, trade secret protection is sitting right there as well. The problem is that as you continue along the path to pursuing patent protection, your application will become public. And as such, your trade secret information to do with the invention will be publicly available. So you need to make a decision about whether you want to rely on trade secret protection or patent protection before a patent application publishes. In general, a complete Australian application will be published on either the earliest convenient date for the Patent Office after 18 months from the priority date of that application, or the date upon which acceptance of that application is advertised. Now, acceptance is after that application is proceeded through substantive examination. Provisional patent specifications, so these are the applications in which you might have made a priority claim, are not published unless a complete application claiming priority from them is filed and published. So in the vast majority of cases, you've got an 18-month window before a patent specification disclosing your invention is going to be published. So that's 18 months where you can still be maintaining trade secret protection and thinking about what's going to work best for you in light of your commercial goals and what you are seeking to do. Now, I would say, while new inventions often start their lives as a trade secret, it is important to make sure that you are taking steps to pursue patent protection before you start doing what's called secret use of the invention. Now, I appreciate that the term secret use sounds a bit vague, because if you're keeping something a trade secret, that does sound like it might be secret use, but it's got a particular context. So in Australia, there is a prohibition on patenting inventions that have been secretly used in the patent area before the earliest priority date. The rationale behind this is to prevent a patentee from enjoying a de facto extension of the patent monopoly. This really is directed to making sure that somebody doesn't keep an invention as a trade secret for many, many years and then perhaps decides to seek patent protection and get their full 20-year patent term on top of that. So the key question to be asked is, has the patentee reaped commercial benefit from what was done before the priority date? There are a number of exceptions to what might be classified as secret use. So use for the purpose of reasonable trial or experiment only, any use occurring solely in the course of confidential disclosure of the invention, use for any purpose other than the purpose of trade or commerce, and any use of the invention by or on behalf of the Commonwealth, the state or territory with the authorisation of the patentee. If you're sitting here concerned about any prior use implications, please get in touch, get some advice as soon as possible, because there is a grace period of 12 months after the first use of the invention. So, coming back to thinking about the overlap. Now, patent application, it's a registered IP right. It's got the plus point that the patent document is made public. So to a certain extent, there is a degree of transparency around the potential scope of protection as well as its term. Trade secrets, on the other hand, you can almost think of them as a bit like vampires. If you keep them under the right conditions, they might live forever, and they're potentially very powerful. However, sunlight, that is public disclosure of your confidential information, can kill them. So when you're thinking about whether to pursue patent protection or trade secret protection longer term, some key questions to ask yourself is, what is your patentability position? Are you dealing with the sorts of subject matter that is suitable for patent protection, or is it something that sits outside the scope of patentable subject matter and might be better protected with a trade secret? Can your invention be reverse engineered? You know, what are the risks of independent development in your technology space? Do you want to put yourself in a position where you might be trying to rely on a prior user exemption? And also think about what your disclosure risks are when you're evaluating whether a trade secret will work for you. Think about how you're going to set up suitable protocols for controlling the distribution and use of that confidential information. Think about your IP governance. And also have a think about what's going to work best for your commercial goals and those of any commercial partners or potential investors. There's no one size fits all. It's all about having a think about your plans, your goals, and the nature of the innovation that you've made. Thank you.
Hello folks, my name's Ian Drew. I'm a principal trademark attorney with Davies Collison Cave, and I'm here to talk to you a bit about considerations for brands within the context of manufacturing. So what am I going to talk about? Well, today there's sort of two themes. The first is going to be use of a mark within the context of manufacturing in Australia of goods which are destined for export. And then also I'm going to look a bit at the international scene, and particularly at China and the way in which they treat this very hotly contested issue. That's really been the world's factory for some time. So a really important consideration for us as Australians seeking to manufacture offshore. So in the Australian context, the question about whether or what the status of a trademark is that's just applied to, for example, goods which are exported, is answered by Section 228 of the Trademarks Act. It confirms that a trademark which is applied in Australia to goods which are to be exported or used in relation to services that are destined for export only does constitute use of the mark within Australia for the purposes of any action under the Australian Trademarks Act. So what does that mean? Firstly, it means that if you're manufacturing goods in Australia for export only, you can infringe pre-existing trademark rights. That's something that you've really got to contemplate within the context of setting up your operations and choosing your brand, even if the product is going to be just exported. Another interesting contemplation around this is that you may be using your mark only for the purposes of exporting goods or services, and your registration may be challenged on grounds of non-use. Well, you can be comfortable that use, that the conduct of that use still constitutes use of the mark in the Australian jurisdiction. Finally, I just thought I'd touch on what is essentially the reason for Section 228. And that's because Australia is a common law system, and there isn't, if we didn't recognise that the use in this context, in the exporting context, was use of a trademark as registered or for the purposes of infringement, we could find ourselves in the situation of having to rely on the common law tort of passing off or trying to bring an action under the Australian consumer law, which may in fact not be available. Now the reason is because those two actions are dependent on the relevant mark having a reputation and the use of the competitor's mark being likely to deceive or cause confusion, or rather mislead or deceive. And that may not be the case when you're talking about a mark which has only been used within the context of exporting. It may not have developed the sufficient reputation to sustain the action. Okay, so I thought I'd just touch very briefly on the idea of exporting services. So, as you would have seen, Section 228 also applies to the provision of services for export only. Look, it doesn't apply in a lot of circumstances. There aren't a lot of circumstances where companies would be only offering a service as an export as opposed to it being internal. But what we can say is that there are some obvious categories of service where this would apply. Consultancy services, online retailing, educational services, these are all very big industries and clearly they cross territory. So we need to recognise that the trademark right is actually still valid within the context of that sort of greater extra jurisdictional commercial activity. Turning to manufacturing overseas, which is really what we're here to talk about, I thought I'll just start with some general principles. The first is that trademark rights vary from country to country. So trademark rights are jurisdictional, and they only arise in the jurisdiction either through use or registration. It's worth noting that broadly there's sort of two different countries in the world. There's countries in which that are common law, have a common law foundation, and they recognise use-based rights. And there's countries which come from the civil law background, and they don't recognise use-based rights. So you only obtain rights in a trademark through the registration system which is in place. Now, fundamentally, and in most countries, it's very clear that the use of the mark for goods or indeed for services which are exported only is still considered use of the mark in the country of manufacture. So you go to Japan, that's the position. You go to the US, that's the position. So fundamental tenet. Further, worth considering that the use of the mark by a manufacturer himself, so this is a manufacturer in Japan who is doing contract manufacturing for a foreign provider, is still in fact using the mark if they apply the mark to the goods. Use of a mark is a sort of a fluid concept, and realistically, sort of in developed countries, the idea is that the mark can be used at multiple points through the supply chain, from manufacturer right through to when it is ultimately retailed, and the goods are handled by the retailer or the distributor. Fundamental tenets to trademark use. Now we're going to dig into China. Okay, so China has for a long time been really the world's factory, and they've had a very extensive network of what they refer to as original equipment manufacturers, or they're often referred to as OEM companies that are manufacturing across all of these for a whole range of clients across the entire world. So in China, trademark rights only arise by registration. I talked about this before. It's a civil law country, so use-based rights don't arise. And in any event, use-based rights, as we talked about, would be dependent on a reputation. There is some special provision in China for protecting rights of those that have got a significant or built a mark with a significant reputation in the Chinese market. But those sorts of rights are never going to arise off the back of use of the mark in the OEM manufacturing context only. Moreover, Chinese manufacturers that are applying marks of foreign entities to the goods which are exported, they're the ones that are typically or potentially in the frame for a type of trademark infringement type action. And so there's lots and lots of activity that's going on there. Now, everyone is out there then looking to protect these brands, and it might be, for example, a company in the UK that's wanting to ensure they can continue to manufacture in China, just as much as it might be a company that is claiming a mark which is coming into China from the US or from Australia. And all of those companies could be using the same or very similar marks. So it's very easy for there to be conflict. And so what we've seen in China is this huge boom of trademark registration. So in the first half of 2020, we saw 4.284 million trademark applications filed, and over 2.5 million trademarks actually progressed to registration. So these are very significant numbers. I'll put that in context. So in Australia, there's only been something like a little over 2 million trademark applications ever filed. So in half a year in China, more trademarks were registered than have ever been filed in Australia in the some 120 years we've been registering marks in this jurisdiction. At the moment, there's over 27 million registered marks in China. And most of these are not marks which are obtained or filed by foreign companies. Most of these are in fact filed by Chinese companies who seek to use the trademark registration system for what it's for, to protect their business reputation. So what are the problems we've had in China? Well, look, everyone talks about trademark squatters. This historically was a significant issue. Chinese bad faith actors were filing for foreign entities marks as a way of creating some commercial leverage or selling the mark back to the party. That really has been dealt with to a large extent by the Chinese government. And there's been this real focus on dealing with the bad faith filing. So I'd like to kind of just park that, because realistically, it's not something which is as big an issue as it was, say, even 5 years ago. It still is an issue, but less of an issue. The other thing to really note about it is it's becoming a very crowded register. It's very hard to clear a mark for use. That's not like really a completely invented word. And some of let's say the examination of trademark rights in China can be a little bit arbitrary. Now, if you're looking at securing your manufacturing base, your supply chain, it can be difficult to ensure that you have that security if you haven't cleared your mark up front, and you can find yourself in the position of potentially infringing third-party rights, or finding that in the future you're infringing because you haven't been able to secure a registration. The other big problem in this space, and that has been the reason why China has been so controversial in the context of what constitutes trademark use is that there's nothing in the trademark legislation which confirms that the use or the application of a mark to goods which are manufactured for export only in China, this OEM manufacturing, whether that constitutes use of the mark in China. They don't have a section 228. So the question has been, well, does that conduct infringe? Would that conduct defend a non-use challenge to a registration in the event that one arose? So what we've seen is some very disparate decisions in China in this space. So I'm just going to touch on really what, the big ones and then explain to you what the current position is. So the Pretel decision there was really considered the leading decision in the Chinese, or in China on this space. And in effect, what happened in that case is that Supreme People's Court, they confirmed that manufacturing by OEM companies did not infringe a trademark registration because the mark was never exposed to the Chinese public. Okay, so if we just think about that for a second, there's no actual use in Chinese commerce, and so it can't infringe a Chinese registration. From an Australian perspective, that feels very unusual. That could be a situation where indeed you're talking about an identical mark that is registered for exactly the goods which are being manufactured. So there's been all sorts of hypotheses as to why the Supreme Court in China decided to go this way. The main one that I've heard is that it is somewhat political, and it's really about the fact that if there was infringement in that context, many of these OEM companies would be shut down. They'll be facing big fines, and that would lead to social issues, that unemployment in relevant areas, and particularly if major manufacturers were guilty of this. The landscape has then been changing from there, and we see in the Dongfeng decision that the Supreme Court then came out and said, well, look, no, okay, it's not enough it's not just open slather. And you can see the political pressure that's coming through from foreign countries in relation to this issue. But it's not just open slather, and what the OEM manufacturers need to do is they need to exercise a duty of care to ensure that their foreign consigners actually enjoy rights in the relevant mark before they engage in the manufacturing. Otherwise, it would be considered an infringement. But importantly, the Supreme People's Court also indicated that they just held that you could discharge that duty by just asking the contractor to demonstrate that the mark was actually owned in the destination country. Now, the Mango decision really applied, I mean, that's the non-use scenario. That applied the Pretel approach to say, well, if you haven't used the mark actually in Chinese commerce, well, then you're not going to be in a position to defend a registration to a non-use attack. So really, this line of authority was a very difficult position for foreign parties or foreign manufacturers interested in manufacturing in China to sort of deal with. It's a considerable degree of uncertainty. It was out of step with the rest of the world. And really, right through this time frame, our firm was certainly advising our clients to be filing to make sure you're trying to secure that position. And it was a good reason for doing that. And that's when we get to the Honda decision. And this is the sort of latest case in this area. It really came out toward the end of 2019. And it has really affirmed, I think, what we all understood as trademark practitioners, but perhaps the business community didn't really fully appreciate as yet. It has flipped the thing on its head. So let's just talk a little bit about the case. It's a relatively simple case. Essentially, you have an OEM company, Chongqing Heng Sheng Group Limited, who is manufacturing motorcycle parts under the Honda kit trademark for export to Myanmar for a Myanmarese company, which is called Meihua Company Limited. Okay, so that's sort of the background. Honda takes action to sue for infringement. Now, interestingly, Honda actually has some rights in Myanmar, but at this stage, there's no actual registration system in Myanmar. You have to sign a declaration in Myanmar to confirm that you claim to be the owner of the mark, and a really underdeveloped jurisprudence around trademark rights. So you can see why Honda wants to take action in China. A more predictable result, albeit their case is running at odds with a number of other decisions. So there must have been a considerable degree of uncertainty as to how this particular matter was going to fall out. But it ultimately ended up with the Supreme People's Court actually finding in favour of Honda, despite that earlier Pretel decision, which was really dictating the attitude of all the attorneys in the Chinese market. So what they said was that actually we need to think about the entire chain of production. Remember how I talked about that before, about the reasons why we need to be worried about who in fact is using the mark? This is the Supreme People's Court sort of validating that position that we've seen around the world. And to give themselves a little bit of wriggle room, I guess, in terms of how to reconcile it a bit with the Pretel decision, they said, well, look, what we're actually doing is we're expanding who the public is. The public actually, in fact, does include operators who are handling the goods in that process of export. So they're part of the public, the Chinese public as well. So if they've seen the mark, then clearly there's use in the Chinese jurisdiction. But importantly, they went on to say that Chinese consumers may be likely to encounter these goods either online or when they're traveling. So if someone, a Chinese consumer, goes to Myanmar and he sees the Honda Kit product, he may well consider or become aware of that mark, and that was considered relevant consideration in the context of whether there's an infringement going on in China where those goods are manufactured. So flips it on its head. And what does it do? It makes it incredibly important for manufacturers in Australia, or rather companies in Australia looking to manufacture in China. They put in place the relevant rights to ensure that they're able to secure their supply chain. So that brings us really to our takeaway messages. First and foremost, pretty much on any trademark strategy, is to think about searching. We talk about this all the time. The number one thing a business does not want to end up in is a trademark dispute in relation to a new brand which you're looking to launch to market. You want to be free to use and register that mark. And in this context, what we're talking about is the manufacturer being able to use the mark or apply the mark to the goods and avoid infringement, and the foreign company also avoiding that infringement. Secondly, we're concerned with being able to register it so we can secure that supply chain. So we don't end up in a situation of some later actor coming along, registering a competing mark, and then using that to undermine your manufacturing facility, forcing you to potentially look at moving your manufacturing to another jurisdiction. Clearly securing registration early is really important. Don't think about setting up your manufacturing arrangements first and then look to mop up the attendance to registration. Get in place the rights before there's any potential obstacle in the jurisdiction. And finally, consider some of the other benefits which flow from registration. You can work with Chinese customs authorities to register details of your trademark rights in China and then use them to stop competitors sending or counterfeiters from sending competing product into your jurisdiction. And finally, if you do see some nefarious activity in China, same with anywhere, consider taking action to restrain, possibly at the choke point, like we saw in the Honda case, to stop the original, the manufacturing point. And that may have benefits across multiple jurisdictions because it would unsettle the competitor's supply chain. Okay, thank you very much. It's been good to talk to you. If you have any questions in relation to branding, feel free to contact me at Davies Collison Cave.
Thank you very much, Craig, Edie and Ian, for some really interesting presentations about very different issues that touch upon manufacturers and people in the R&D space. No questions have come in from anyone attending yet, so I'll mention that all the presenters' PowerPoint slides will be emailed out to you shortly, and that email will also contain the presenters' contact details. So as Ian said, don't hesitate to get in touch with anyone if you do have any questions. Otherwise, I think all that remains to be said is that I hope everyone has a lovely weekend, and thank you very much for joining us at this webinar today.